So now we move to section 184. So which is something, which is the medical examination of the victim of rape, which is section 184, BNSS. Now, by the plain reading and trying to understand from the section is that where during the stage when an offense of committing rape or attempt to commit rape is under investigation. So in such a case where an offense of committing rape or attempt to rape is under investigation, it is proposed to get the person of the woman with whom rape is alleged or attempted to have been committed or attempted examined by a medical expert. So in both the situations, it is very, very important that that person is has been is being examined by a medical expert. Now, such examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or a local authority. So it has to be done by a medical practitioner, which is employed in a hospital run by a government or a local authority. In the absence of such a practitioner, by any other registered medical practitioner is also possible, but with the consent of such woman or of a person competent to give such consent on her behalf, and such woman shall be sent to such registered medical practitioner within 24 hours from the time of receiving the information relating to the commission of such offense. So now in BNSS, everything has been compressed into one single section, subsection part 1, which we have seen in CRPC earlier. It was pretty complex. It was talking about can be done by medical practitioner, who is under so and so exception, blah, blah, blah. We have studied earlier. Now, this is very clear cut saying it has to be done by a registered medical practitioner. The definition is already known to us, which is registered by the particular act and the rules. And it's a government authority, the local doctor from the such government hospital, in case such a doctor is not available, even by any other registered medical practitioner, but with the consent of such person, either the woman herself or any person who is competent to give such consent. The subsection 2 says the registered medical practitioner to whom such woman is sent shall, without delay. Now, it has to be done within 24 hours. Why? Because the biological evidences will be very grim, thin, or negligible after 24 hours. So that is why it has to be done within 24 hours. That is why the recommendation is made that way. Although it is ASAP, as soon as possible, has to be done. So the registered medical practitioner to whom such woman is sent shall, without delay, examine her person. So there cannot be a delay expected from the medical practitioner also who is examining, and prepare a report of his examination giving the following particulars. So following particulars are mandatory to be part of such a report. So the name and the address of the woman and of the person by whom she was brought. So who has accompanied the person, that person's detail also has to be recorded as in accordance to point 1 of the subsection 2. Then the age of the woman, the description of the material taken from the person of the woman for DNA profiling. So whatever material has been taken from the person of the woman for DNA profiling, it might be some biological substances from on her body, on her clothes, or within her nails, etc. The marks of injury, if any, on the person of the woman, so that has to be photographed as well. So when the marks of the injuries are described, the form, if you see, there is a particular form given by by the government where a whole body of a male and a female is drawn there. So the marking has to be done also where the injuries have been found and what is the depth of the injury, what kind of injury, etc., etc. And general mental condition of the woman. So what is the orientation of the woman? Is she afraid? Is she anxious? Is she shocked? So all those things have to be recorded, which is giving the physical recording will only not give the correct picture of the situation to the judicial officer later when it will be examined, or anybody whomsoever is examining the paper. It will also be given by the mental condition or makeup of the woman. So that is why it is also recorded, and other material particular in reasonable detail. So any other material particular, whatever is required has to be added there in reasonable detail. So there are multiple tables there. So the tables are there in that particular document. That is a mostly 8 to 10 pager document. It has a various categories of psychological evaluations, which has to be checked yes, no, not applicable. Somewhere you have to write some small text. Then there are various kind of activities which could be performed with that particular person, which would be on sexual in nature. So all those have to be checklisted there, that whether an oral activity has been performed, whether a penetration has happened. So all those things as checkboxes, etc., are all available there. So all the records, general records, are also made, which is reasonably given in that document. The subsection 3 says the report shall state precisely the reason for each conclusion arrived at. So every conclusion on the whichever is arrived, the whatever is wherever required, the reasons are has to be written there. And the report shall specifically record that the consent of the woman or the person competent to give such consent on her behalf of such examination had been obtained. So, in what conditions the consent of the woman will be taken? If a woman is an adult and she is in a conscious state to able to speak, write, understand. Otherwise, if she is in a situation with probably in a vegetative stage, unconscious, not in a good mental state, nervous, anxious, in all those conditions, or maybe minor or of not of a firm state of mind or some kind of uh, uh, cognitive disabilities. So in all those cases, a parent or a somebody who is competent. So parent, husband, any family member or anybody who could be competent, probably an NGO or a neighbor, anybody could come and write on behalf. The exact time of commencement and completion of the examination shall also be noted in the report. So it has to be clearly noted that what time the uh, commencement of the examination started and when it finished. So this also gives a clear indication to the court later to understand that when the person was brought from the police records, it will be shown and the diary entry will show, and then what time the medical examination actually happened. Because in some of the cases, the delinquency has been found where a police diary shows on, say, on 1st of January, the person was brought to the hospital, while the medical examination timing shows it happened on the 2nd or 3rd. So that also happens. So that is why it was made mandated to put the exact time and of commencement and completion. Subsection 6 says that registered medical practitioner shall, within a period of 7 days, forward the report to the investigating officer, the IO, who shall forward it to the magistrate referred to in section 193 as part of the documents referred to in clause A of the subsection 6 of that section. So basically, it is the medical practitioner, whoever is doing it, it goes to the his boss, the person who is the medical officer of that particular, the chief medical officer, CMO. And with all this validation, verification on the content of the document, if any further entries have to be made, is done, stamped, seal, and it has to be sent to the collected by the police department by the hospital, from that hospital, and it goes to the investigating officer. Investigating officer normally clubs it into the charge sheet when they are presenting it to the court, and that is part of the charge sheet. Subsection 7 says nothing in this section shall be constructed as rendering lawful any examination without the consent of the woman or any person competent to give such consent on her behalf. So it is by default, it has to be consented. The consent is very, very important, and that has to be definitely rendered by either the woman herself or by anybody competent to do that. For explanation is given for the purpose of this section, examination and registered medical practitioner shall have the same meaning as respectively assigned to them in section 51, which is the definition of examination and definition of the registered medical practitioner. Now, what is this section 184 talking about? This is talking about authority to medical exam a lady who has undergone a sexual attempt of some kind of crime, or some crime has been committed. So this is a procedure for a medical examination of a female victim of rape or even attempted rape during ongoing police investigation. So this is something to ensure the timely medical attention is provided to the lady, and the primary evidences on person of the lady is collected. So subsection 1 clearly only talks about how the examination has to be conducted and by whom. So it says it has to be done by the registered medical practitioner, primarily from a government or a local authority hospital, and then such a practitioner is unavailable, that may be performed by other registered medical practitioner with the informed consent of the person, the lady herself, or any competent person taking decision on her behalf. And it has to be done within 24 hours of this particular report of the offense. The documentation requirement is defined in subsection 2, which talks about the various details in the medical record. Primarily, it talks about, of course, the identification of the report by the name of the person and the person who was brought. the victim's age, the detailed description of any sample collected for the DNA profiling, any visible injuries on the victim's body, and any assessment of the victim's general mental condition and other relevant data which are part of the various checklists and the tables in the document. So this is a very comprehensive document which gives a complete detail of the situation. In fact, every injury is drawn as a picture on the document where a full body diagram and then of a private part. There are two images on the document, and the full details of every injury with the location circled is mentioned there. Subsection 3 and 4 talks about the clarity and the consent. It says the reason of the finding. The reason must be clearly articulating. It has to be, the report must be clearly articulating the reason for any conclusion drawn by the medical practitioner. So medical practitioner normally put the conclusion at the end of that particular report. There is a section where they write a full detail bullet wise. And consent is something which is very, very important. Otherwise, this whole document would not be of any worth until and unless it is not consented. But yes, there had been exceptions in the history as well, where there was somebody found who is found alone somewhere. There is no identification of the person. The person herself in a vegetative state. She's not able to respond. There is nobody who is available to sign the document on their behalf. In those cases, the police officer who was accompanied could also sign. The person who has recovered the person, either the person citizen who has informed is also able to sign, or the police officer who has identified and recovered the person from that particular location can also sign. Timekeeping is a very important aspect of this particular section, which says the exact timekeeping of commencement and completion of this particular examination must also be recorded. And a submission of a medical report has to be done within 7 days to the investigating officer, and then in turn through to the magistrate from the investigating officer. There is no examination which can be deemed lawful if it is conducted without a consent of the woman or a person authorized to give such consent on her behalf. So this is vital, very important, ensuring that the victim's rights are upheld and they are not compelled to undergo anything without their approval. Practical implications is protection and sensitivity. It is very sensitively configured section. It gives a protection. It is very important that it takes care of the within 24 hours thing. The commencement has to happen as soon as possible. And all those clauses are nothing but importance of the timeliness of the collection of the evidence, because the nature of the evidences are biological. It's very easy to get it washed off, dropped, scattered, or destroyed. And this also, with the time and the sequence of reporting, facilitates the investigation and also proceeding it to the judiciary in as soon as possible. If we see in some total, it says as soon as possible, within 24 hours, the examination has to happen. Then within 24 hours, the commencement has to happen immediately. And then within 7 days, the judiciary should have the police should have the report, and the police should be able to bring in the report to the magistrate then after that as soon as possible. So it tries to minimize the timeline in between to ensure although a proper documentation and investigation should happen, but then it should also reach quickly to the courts. So this is about section 184, which is a part of the interrogation power of the police officer, chapter 3. Section 185, which is search by police officer. So whenever an officer in charge of a police station or a police officer making an investigation has reasonable grounds for believing that anything necessary for the purpose of an investigation into an offense which he is authorized to investigate may be found in any place within the limits of the police station or which he is in charge or to which he is attached, and that such thing cannot, in his opinion, be otherwise obtained without undue delay. Such officer may, after recording in writing the grounds on his belief in the case diary, and respectively in such writing, so far as possible, the thing for which search is to be made, search or cause of search to be made for such thing in any place within the limit of such station. So it is always written in any of the sections, if you have noticed until now, that whenever we talk about the officer in charge of police station, we also mention a police officer making investigation from the same police station. So why this is written that way is because it is the primary authority of that particular station in charge of the police station, but because of the distribution of the work, the way we have the CJM and the other magistrates, so it has to be delegated at the right ranks, and that is why it is always included or statement with the station in charge and the other police officer, because it will be mostly done by distributed with multiple police officers of the right ranks to be doing that investigation as per the central government or the state government indications through various GRs or notifications. So in this case, a police officer in that police station, if they believe there is very much necessary for any investigation, which he is authorized to investigate, that is also very, very important. He may be found, he believes that within the jurisdiction limit of the police station where they are present, and or they are attached. Why the word attached is used? Because sometimes the person might be not directly part of that police station, but they might be attached to the police station or multiple police station for certain specific roles. So if they are attached to that police station, in that case, if that they believe that for that particular investigation for their which they are authorized, and they believe there is certain things which could not be obtained without which has to be obtained without any delay, and they have to go back and find and search that thing in those places. So within limit of such station, then they have to first of all make a diary entry in the case diary to specify clearly that on what ground they want and why, what is the reason they want to go ahead and do this investigation, and as much as possible, what search they are actually, what exactly they are trying to find. Why this is important? Because the section 185 subsection 1 mandates this procedure to ensure there is not an arbitrary search by the police. They become accountable and responsible. There is a responsibility that if they go for a search, that is for a valid reason. And that is where if contradictory situations are found, where a search has happened and there is no such writing is reduced in the case diary, and even no such kind of entry is not made for some kind of search article, it could be very much challenged in the court as an arbitrary procedure by the police, and it might be a malfunction or a malice intention done by the police also. So that is also something which becomes invalid in later in the court of law. It might be the such findings might be invalidated. So that is why it is very important for the police to follow the subsection 1 of 185 in case of they are searching any article. The more the details are written and the more it is detailed, the more it is trusted. Subsection 2 says a police officer proceeding under subsection 1 shall, if practicable, conduct the search in person, provided that the search conducted under this section shall be recorded through audio video electronic means, preferably by mobile phone. So if practical, they can do somebody's body search also. And in that case, the search has to be, when they are doing in person, they are doing those searches. The police officer is present there and they're doing their search. In this situation, they can do a audio video recording through electronic means. So it has to be something which is through audio video electronics. It cannot be just a video, which is also doubtful because you don't know exactly what is happening just by seeing the videos. And it cannot be certainly in audio because there's no clue about where it is happening. Subsection 3 says if he is unable to conduct the search in person, so if he is not in person, he is not doing that, probably he can, there is no other person competent to make such search present. So he is no officer at that point of time who can do it also for himself, for his instead of he going in person and doing such kind of searches, he is no other person competent is also available. He may, after recording and writing his reason for so doing, require any officer subordinate to him to make the search. So he can go ahead and he can do a subordinate, a junior officer also, who can go ahead and do the search, and he shall deliver to such subordinate officer an order in writing. So the person, as we see, the officer has to do it himself or herself, and if there is no officer, it is not possible. Sorry, no, not possible for the officer to do it in person. The search, the person can do it, uh, delegate it to a subordinate, but it has to be reduced in an order which is written in writing, and specify the place to be searched so far as possible, the things for. So as per the compliance of subsection 1, where it has to be made the search, and where what kind of search has to be done, on what kind of things has to be found, such things are reduced in the writing in the order which is handed over to the subordinate police officer, and so that that person is enabled to do the search on behalf of, because in person he is not able to do those searches. Subsection 4 says the provision of this Sanghita as to search warrant and the general provision as to search conducted in section 103 shall so far as may be apply to search made under this section. So very same thing will happen. The same procedure will be used for search using warrants as detailed in section 103 earlier. Subsection 5 says copies of any record made under subsection 1 or subsection 3 shall forthwith but and not later than 48 hours be sent to the nearest magistrate empowered to take cognizance of the offence, and the owner or occupier of the place search shall on application be furnished free of cost with a copy of the same by the magistrate. So report has to be sent within 48 hours to the magistrate, and if the person who is owning that particular premises where you made the search on request of him, so if the person makes an application, a free of cost copy has to be given. So 185 is talking about authority to conduct search of a police officer or a subordinate police officer whom it could be delegated. So this grants a police a permission, officer a specific right in charge of police station to an authority to conduct searches when they have reasonable ground to believe necessary evidence has to be collected in a case of a cognizable offense and it is found in a particular location. And the critical aspect of this section is that the officer must be convinced that this evidence cannot be obtained without undue delay. So they cannot wait for it. There might be some reason it might be transferred to some other places, it might be destroyed, whatever it is. So substantiating the urgency, necessity of the immediate action, they have to make a diary entry. So the second part of the subsection, the subsection 1 is documentation of the belief. So whatever documentation in this regard the police officer is convinced of, and as much as possible about not about the location, but exactly what they are trying to find also, which is normally known. It's very rarely they will not know what they are trying to find, but in case that is, if that is the case, they have to make as much detail requirement, the reason into the case diary. While the conducting the search, subsection 2 says either do it in person, the officer, if not possible, it can be given to some other officer as well. And whatever the search is being done must be documented using audio, video, electronic means. So preferably through mobile devices. This provision enhances the transparency and ensures accurate records of the search process. So if you see the wordings here of the section, that uh, provided a search conducted under section shall be recorded through audio, video, electronic means, preferably by mobile phone. So it says, uses the word shall be. So it has to be used. These things are mandated by the BNSS. The delegation is already discussed in subsection 3. We just talked about it, where it could be delegated to other officer, subordinate to the officer if he is not able to do it in person. And in persons, if it is not possible, the delegation, when it is happening, it cannot be verbal. It has to be reduced in writing as an order with giving the reason of the search, number 1, number 2, the place of the search, and number 3, if possible, as much as about what exactly the person is going to find on behalf of this officer. And section 4 talks about applicability of the search warrant provisions also, which will operate in the same similar way. And the reporting requirement is also given that within 48 hours, it has to be reaching to the relevant magistrate, and on request of the owner or the occupier of that particular such property, on an application of the person, it has to be given to the person without any charges to be collected from that person. So it gives a practical application. It talks about the accountability also while doing the search, because they are not simply jumping into the search without making any record prior to the search. Now, this is very, very important. The case diary has to be done prior to the search with a reason, because government has given the authority to the police officer a wider perspective. Considering the sensitivity of the matter, the police can go ahead and make a search. So that authority is given. But then, similarly, there is a provision also talks about giving a first-hand details about why, where, and what information about the search, and then it has to be done, which is the logical way anybody would operate in that reasonable reasons. If somebody is not putting that and going ahead and doing a search and then coming back and writing on the case diary, that is also not acceptable, because then that shows some kind of misuse of power. The respect of individual rights is also shown here, that there is a justify to the search, and the police officer has to inform the property owners who occupies that particular place, and there is no arbitrary action. They have to go back and tell, this is the reason what we have made in case diary, and that is why we have come here to so and so, to recovery of so and so thing, which we believe it is here and it has to be collected immediately. And that brings an efficiency in the investigation without putting any cobweb of processes where the precious time might be lost. The accountability is created by the diary entry to the police officer, where they are accountable, but their investigation is not retarded or slowed down just because of need of some external permissions or permissions from any court or other places. So that is why it is a very efficient way given to the police officers to do a search in a place where they want or they believe something might be hidden, and it is very important to bring it out as soon as possible for the sake of that investigation, and that in a cognizable offense. So if there is a non-cognizable offense, there, if in spite of this being a situation where he believes something, he cannot go and search the premises without a search warrant. So that is also very much applicable. If you read the reverse way, the same section. Section 186, the next section, the title is when officer in charge of a police station may require another to issue search warrant. So an officer in charge of a police station or a police officer not being below the rank of a sub-inspector. So this is applicable to anybody who is not below the rank of a sub-inspector making an investigation may require an officer in charge of another police station, whether in the same or different district, to cause a search to be made in any place, in any case in which the former officer might cause such search to be made within the limits of his own station. So officer in charge of police station or a police officer not being below the rank of sub-inspector, when they make an investigation, they might require the officer in charge or some other police officer, of course, not below the rank of the sub-inspector, in the same or a different district. So any district change is also possible, but in same district also multiple police stations, to cause a search to be made. So they have to get a search to be done in any place, in any case in which the former officer, the officer which is in the first place, might cause such search to be made within the limits of his own station. So, as if he is doing the search in his own police station. Such officer, on being so required, shall proceed according to the provisions of the section 185 and shall forward the things found, if any, to the officer at whose request the search was made. So, this is something which is a delegated search. And in the delegation of search, when the first police station officer goes to informs the second police officers, and they want that to happen, of course, it has to be done by the second police station officers in exactly the way it is written in section 185. Whenever there is a reason to believe that the delay occasion by requiring an officer in charge of another police station to cause a search to be made under subsection 1 might result in evidence of the commission of an offense being concealed or destroyed, it shall be lawful for an officer in charge of a police station or a police officer making an investigation under the chapter to search or cause to be searched any place in the limits of another police station in accordance with the provision of 185, as if such place were within the limits of his own police station. So it is very much possible that in case if the police officer has all the reasons to believe, which he has to write in the case diary, that entry also has to be made. It is also an empowerment given under section 186 that either they choose to take an help of the other police station, or they can directly do the search in the other police station's jurisdiction area also. They are very well empowered under section 186 subsection 3 if they believe that is the most efficient way of doing that particular search and recovery. Subsection 4 says an officer conducting a search under subsection 3, which is an officer which is doing a search and recovery under subsection 3, which is an officer doing in some other police station's jurisdiction in same district or another district, shall forthwith send a notice of the search to the officer in charge of the police station within the limits of which such place is situated, and shall also send with such notice a copy of the list, if any, prepared under section 103, and shall also send to the nearest magistrate empowered to take cognizance of the offence copies of the record referred in section 1(3) of section 183. So any officer who is conducting a search that way, directly going into it, shall forthwith send a notice of the search to the officer. So in practice, when they go to that area, they send a notice and immediately rush to that place to make a search within the limits of the other police station. And then it has to be informed to the nearest magistrate as well. So, subsection 5 says the owner or occupier of the place search shall on application be furnished free of cost with a copy of a record sent to the magistrate under subsection 4. So any record which was sent to the magistrate, the same report has to be sent to the owner and occupier in this situation also, whether the person is the same district, different police station jurisdiction, or different district, different police station jurisdiction, of course. So what does the section talks about? Authority to require searches. So if there is a requirement of search, and it permits the officer in charge of police station or a police officer not below the rank of sub-inspector to request an officer in charge of another police station to conduct a search in another location. And this is pertinent when the requesting officer believes that a search should be performed outside their jurisdiction, but still within the confines of legal authority. So it is also allowing a cross-district authority as well. The procedure what is followed is in subsection 2, which talks about upon receiving a request to conduct a search, the officer of the other police station is mandated to follow the procedure established in section 185, and after conducting the search, any item found must be forwarded to the officer who requested the search. So if the other district police or other police station police from the same district is doing it, they will forward everything back to the same police officer, ensuring there is a continuity. So they do it on their behalf, fill up the activity on their behalf, and then send it back to them. So this ensures a continuity and accountability in the investigation process. And that is how. So when in case of a delegated responsibility also, it has to be a written application which has to be given to the written notice has to be given to the other police station in case this happens by the other police station. Now, if there is a reasonable belief, there is a delay which is going to happen, it can be done by themselves also, the first police station, and directly that it can be done and allows the officer to act swiftly in these critical situations and where evidence might be lost. There might be sometime strong belief that the police station in that area is probably too busy, not possible. Maybe they're hand in glove with those people, or maybe a secret action is required without informing too many people in that area. So in that case also, it gives a very strong position to the police officers to make a search directly instead of asking the other police station to do it. Now, notification of the document is part of subsection 4, which says an officer conducting a search under the emergency provision, which is subsection 3, must notify the officer in charge of the police station where the search took place immediately. So normally, wherever the search is took place, they go back and give the notice to their police officer. So they will either give the notice to the police officer, do the search, or they do the search and inform the police officer. Either way, it is fine. So they must also provide copies of the relevant documentation, including list, etc. Whatever, if they are doing under warrant, they have to also provide a copy of the warrant, etc. And the record specified under that particular subsection 13 of 185, whatever is given. And this ensures a proper tracking of evidence. So they are, if it is very, very sensitive, it is also allowed to them to first do the search and then give the details to the notice to the police officer of that police station. Because what is important, the most important thing why this emergency provision is added is in the situation of an emergency situation or exceptional situation where a very sensitive information might be lost. In that case, the priority is given to the search first. So the officer, in spite of being from different jurisdiction, might jump into that locality of that jurisdiction, conduct a search, recover the things, and then they can also provide a notice afterwards also to the police station. That is also allowed. And rights of the owner and occupier is carried as in 185 and 186 also, and uh, they are eligible for a free copy for whatever report was submitted to the magistrate, the search and other reports. So it is an interagency coordination, which what we call in the police language. In interagency of the police, they are conducting the search. It's a protection of the evidence, which is very, very important, which is part of 186. Why 186 is in place is protection of the evidence. Irrespective of the distance and the jurisdiction of the from that police station, in the continuity of the investigation of a cognizable offense, it gives a protection of evidence power to the police to ensure that without any delay, without any too much of complication, without even going via, they can directly go ahead and recover the things as required in case of that particular success of that investigation. And they have a right to go back and search first and then inform the police station later also. That is also okay under this section. And this gives the public a very strong trust that police can overshoot from their personal jurisdiction if required to collect those evidences if it is believed to be stolen, lost, or removed, destroyed, etc. So this is something, it's a very, very important section which extends from 185 as a special provision in case 185 has to operate in a jurisdiction out of the jurisdiction of the police who doing the investigation. But it does give a minimum requirement of the police rank is sub-inspector who can conduct this kind of operation. Section 187, it talks about procedure when investigation cannot be completed in 24 hours. Now, we know that whenever any person is arrested and detained in a custody and it appears that the investigation cannot be completed within the period of 24 hours, fixed by the section 58, it says we cannot keep a person without any court's permission for more than 24 hours. And there are grounds on believing that the accusation or information is well founded, the officer in charge of the police station or the police officer making the investigation, empowered definitely by the police officer, if he is not below the rank of sub-inspector, so not below sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary hereinafter specifying relating to the case and shall at the same time forward the accused to the such magistrate. So they have to produce the person to the magistrate immediately and they have to come back with a reason. So the person either has to be in police remand or then it has to be in the magisterial remand. So to continue with the police remand, after 24 hours, the police officer has to file the reasons why he is required more for to be with the police it is very essential for completing of that investigation. And if there are strong reasons, in that case, they can come back to the magistrate with the person. The body also has to be brought to the police station, as they say in the habeas corpus. So the body has to be brought to the police to the court, to the same magistrate where that particular matter is being subjected to, which has got the jurisdiction, and then the reason has to be provided to the magistrate, and it has to be solid and crisp reason. Of course, the accused also, in that case, who is in remand of the police, has a right to represented by an advocate to challenge that as well. Say, for example, in one of the previous cases, there was an accident which happened by a person, and because of the accident, one person was dead in Hadapsar and 2-3 people were injured. In that case, the police wanted a remand of the person. They wanted to continue the person to be in the custody of the police for more than 24 hours for next 2-3 days more, which was not a solid ground, because if there is an accident which has happened by a person, which is not something is a planned criminal activity or a criminal activity in general. So in that case, a person who is a civilian, who has got no criminal record, who is able to provide all his details, Aadhaar card, PAN card, and all those things related uh, uh, to the vehicle transport, the vehicle and his license, etc. There is no reason a police will need a remand for more than 24 hours for that person to investigate anything which is related to that particular accident. So in that case, the arguments would happen and the police remand might be discarded by the magistrate. So they have to come back with the right reasons. That is what is mentioned in subsection 1. Subsection 2 says the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days, as per BNSS, in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days, as the case may be, as provided in subsection 3. And if he has no jurisdiction to try the case or commit it for trial and consider further detention unnecessary, he may order the accused to be forwarded to the magistrate having such jurisdiction. So I'll come back to this in detail once we read the complete section. But in nutshell, this talks about the magistrate can even irrespective of has he has or has no jurisdiction to try the case after taking into the consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused. They can also allow the detention of the accused. So why this role is given? This is a specific magisterial role where they are considered an authority to take decision in this part for any urgent situations. So they can do that. And this cannot, as per BNSS, there are some timelines which are specified, which was different in part of the CRPC. So the detention of the accused in such custody, they may think fit, but for a term not exceeding 15 days in whole. In whole. So please understand the statement made here is for a term not exceeding 15 days in whole, which means it can be achieved in part-wise also, the 15 days. So, or in parts. So, which means any time during the initial 40 days or 60 days out of the detention period of 60 days. So, either initial within 40 days or 60 days out of the detention period of 60 days, or so when the 60 days, 40 initial 40 days has happened in that period, the total 15 days or 60 days out of the detention period of 60 days or 90 days, as the case may be, as provided in subsection 3. We'll give you example after this. Subsection 3 says the magistrate may authorize the detention of, in case if also it says, in case the magistrate has no jurisdiction to try the case or commit it for trial, then they can consider further detention unnecessary also in that case. He may order the accused to be forwarded to the right magistrate to further proceed, because he can only take a decision for something which is urgent, like a person has to be detained to the police for the sake of the investigation. But beyond that, he cannot try if the magistrate does not have a jurisdiction. Subsection 3 says the magistrate may authorize the detention of the accused person beyond the period of 15 days if he has satisfied that adequate ground exists for doing so, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding 90 days, where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more. So now not more than 90 days. And 60 days where the investigation related to any other offense, and on the expiry of the said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to and does furnish the bail. If he is able to furnish the bail, he will be released on the bail, and every person released on bail under this subsection shall be deemed to be so released under provisions of chapter 35 to the purpose for the purpose of that chapter. Now, no magistrate shall authorize detention of the accused in custody under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in custody of the police. So, it cannot happen that the person is not brought to the magistrate and only via an application of the police in the police station. For the police station, this can happen. And every time which is required, then the person has to be produced in front of the magistrate, but the magistrate may extend further detention in judicial custody on the production of the accused either in person or through the audio video electronic means also. So audio video way also it is now being done, where a person could be uh, presented in front of the magistrate through some kind of audio video conferencing. Subsection C6 says no magistrate of the second class, not specially empowered in this behalf of the High Court, shall authorize detention in the custody. So no JMC can take a decision until and unless some JMC courts are authorized by the High Court for the sake of probably a work distribution, which might be on request of the district judge. So, explanation 1, for the avoidance of the doubt, it is hereby declared that notwithstanding the expiry of the period specified in subsection 3, whatever periods are given, the accused shall be detained in custody so long as he does not furnish well. So, for the avoidance of any doubt, it is declared in this section that notwithstanding the expiry of the period specified. So, within the expiry of the period specified, subsection 3, the accused shall be detained in custody so long as he does not furnish bail. So, if there is no bail given, the person will be detained in custody. Explanation 2. If any question arises whether an accused person was produced before the magistrate as required under subsection 4, the production of the accused person may be proved by his signature on the order authorizing detention or by the order certified by the magistrate as to production of the accused person through the audio video electronic means as the case may be, but provided that in case of a woman under 18 years of age, if somebody, there is a woman who is the accused here for under 18 year age, the detention shall be authorized to be in the custody of a remand home or recognized social institution, and the provided further that no person shall be detained otherwise than in police station under police custody or in prison under judicial custody or a place declared as a prison by the central government or the state government. So there are the clarification given, special clarification given for the female, that the detention of the female cannot happen in the police station. It has to happen in a remand home or a recognized social institution. While for the men, it has to be in the police station and the police custody when they are in police custody, PC, and in case of a judicial custody in a prison or a place which is declared as prison. So why it is written a place declared as prison? Because in some of the small districts, etc., there are some small buildings where some security provisions are made and they're declared as jails. So there are many such jails in Maharashtra also, where these are part of some sub part of a school or some kind of government building, which is defined as one of the jails. So if during police custody, the people could be kept there as well. Subsection 6 says, notwithstanding anything contained in subsection 1 to subsection 5, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of a sub-inspector, may, where a magistrate is not available, now magistrate is not available, transmit to the nearest executive magistrate or on whom the power of magistrate has been conferred a copy of the entry in the diary hereinafter is specified relating to the case, and shall at the same time forward the accused to such executive magistrate, and thereupon such executive magistrate may, for reasons to be recorded in writing, authorize the detention of the accused person in such custody as he may think fit for a term not exceeding 7 days in the aggregate, and on the expiry of the period of detention so authorized, the accused person shall be released on bail, except where an order for further detention of the accused person has been made by a magistrate competent to make such order, and where an order for such further detention is made the period during which the accused person was detained in custody under the orders. So this is a special case when there is a magistrate which is not available. If magistrate is not available, then you can make a you can bring the person to the executive magistrate on which those special powers of magistrate are conferred. But then the executive magistrate can extend the detention to max of 7 days and not more than that. And any extension beyond that, and that is also aggregate. So it could be aggregated with multiple detentions, but not more than 7 days. But a period beyond that has to be always done with the permission of only a judicial magistrate. So no further extension can be done by an executive magistrate in this case. So, provided that before the expiry of this period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate the records of the case together with a copy of the entries in the diary relating to the case which was transmitted to him by the officer in charge of the police station or the police officer making the investigation, as the case may be. So, in this period, when the accused person was detained in the custody under the orders made by the executive magistrate, the subsection under this subsection, the executive magistrate will transmit it to the nearest judicial magistrate, and then with all the records, because before sending it to the executive magistrate, the police has also made a diary entry. So that diary entry about with the from the police station which was received, plus their own reasoning and reason were what was given by the executive magistrate for the 7 day aggregate detention, it has to be sent to the nearest judicial magistrate to take further action on that in this situation. So this 187 talks about investigation timelines and reporting also, and process followed by when police investigation cannot happen within 24 days hours timeline, and reinforce the need for oversight and accountability in case of involving detained individuals. So detention required in case of the investigation is not possible to complete in within 24 hours. That's the belief of the police. So please understand, this is uh, uh, also talking about not only about the investigation required for more than 24 hours plainly. It talks about investigation which police believes cannot be completed by 24 hours, because this is only one side, or from the side of the police, which is represented in section 187 with the procedure to apply for further extension by the police. So requirements following the arrest is given in subsection 1, which talks about a person is arrested and detained, and the police officer recognize that the further investigation can not happen without the person available to them. So the person is needed further to be in the police remand, and they have to go back and immediately reach out to the, without any delay, to the magistrate together with that person. So the officer must transmit first a report to the nearest magistrate, providing the details. That is nothing called the police remand report. We call it a PRR in the court language. So PRR has to be transmitted to the nearest magistrate, which is the police remand report. In case the police wants to go with executive magistrate, a PRR plus a diary entry also has to be shown. Although a diary entry is also shown in case of judicial magistrate also, but it is not mandatory. Mandatory is it's in the case of executive magistrate, but PRR is common. So in justifying the reason for the inability to complete the, why it is enabled, they are enabled to, they will be enabled to complete the investigation if the body, the person is not available to them. But they can also forward the arrested person to that magistrate and make him present in front of the magistrate, so that the magistrate can visually see the person also and make an assumption, presumptions also about the health and the fitment of the person who is available there, and the person is in a good shape available, because that is a judicial uh, oversight also which is required by the courts, by the magistrate, sorry. So magistrate discretion. Now subsection 2 talks about the magistrate's discretion in this case. Now, as I said, this is a perception, this is something which is a case brought forward by the police station, that I cannot do an investigation if it is more than 24 hours and if the person is not available. Then it's a magistrate's discretion that on receiving that accused person, the magistrate possess the discretion to authorize detention in custody of a period not exceeding 15 days. So it cannot beyond 15 days, total 15 days. More than that, the magistrate cannot detain, considering where the individual has been released on bail or if their bail has been cancelled. So that is a consideration, that it is he is released on bail or his bail has been cancelled. Now, jurisdiction flexibility, what is given here is the magistrate has no jurisdiction to try the case also. Still, that particular magistrate has an authority to work on the detention, and they can allow the detention to help the investigation on a priority basis. Extended detention is defined in section 3, where the magistrate can authorize the detention of an individual beyond the initial 15 days also, if they are able to determine there are sufficient grounds for doing so. However, there are limits to total detention period on that. What are the limits? Up to 90 days for offenses punishable by death, life imprisonment, or term of 10 years or more. So, in those cases, up to 90 days of detention could be extended, and up to 60 days for other offenses, which is after these periods, uh, individuals must be, then after this period of 90 and 60 days, the person has to be released on bail unless the court order further detention. So although the provision talks about the maximum time of 90 and 60, but it is still giving further power to the magistrate to be able to still allow the person to be detained. That is also possible. But this is a limits on the total detention period. So the 90 and 60 days, when we talk about the limits on the total detention period being extended, this is not 15 plus 90 or 15 plus 60. This is inclusive of 15, the 90 and 60. So procedure on the detention is giving subsection 4. The accused must be produced before the magistrate for the initial hearing and every subsequent hearing during their custody. So if the police has to take a custody, extend the custody for the first time or any other time next further, they have to definitely, as per procedure, bring the person, whoever is in custody, in front of the magistrate, which is giving a judicial oversight. Then the magistrate can extend the detention in judicial custody through a personal appearance or virtual mean also. So they can do a police custody extension, or they can go ahead and increase the detention period. But appearance is which were virtual mode is also allowed, which is maintaining the integrity of the judicial process while accommodating the practical constraint also. So even the person who is in the police custody or judicial custody, either way. For example, Yerwada jail has about 14 different rooms which have audio-visual units nowadays, which helps the police to not bring out the jail authorities to not bring out people physically. If they want, they can also present the people from right within the campus of the jail through audio-visual conferences. Subordinate officers and executive magistrates, their role is defined in subsection 5 to 6. So subsection 5 to 6 talks about the subordinate officers and the executive magistrates. So if a magistrate is unavailable, the police officer may forward the details to an executive magistrate also, who can authorize up to 7 days a custody. While this ensures continuity legal process, it is an again helping in the urgent condition. So we see two things in this section, which is catering to the urgent need of the investigation. One, where the magistrate is, even if not in the jurisdiction where he can try that matter, still in the matter of detention, which is very, very important for the sake of the investigation to continue and prioritize the investigation, that magistrate, in spite of being not of that jurisdiction, can allow. Similar way, in case there is no magistrate available, the executive magistrate can also extend up to 7 days. And any detention authorized by the executive magistrate is accounted for within the broader context of the custody period specified for the case, ensuring that the total detention limits are respected. So even 7 days detention is done by the executive magistrate, and for some reason, if the 15 days has to be respected and not going beyond that, the other magistrate cannot give a uh, can only add up to more than not more than 8 days of custody. So the overall number cannot be disregarded. It cannot happen that if the detention limit is for 15 days, it will reset when it will go to a judicial magistrate. No. So it takes care of the liberty of the person, the rights of the accused also, and accountability to the police also, because until and unless there is no strong reason provided, they cannot get hold of the person. And practical implication is ensuring a timeline in the judicial oversight, but it is also balancing police authority and judicial review to ensure the police is not going beyond their powers to just for the sake of holding the person to put some coercive pressure, and incorporate any flexibility on the investigation by various options of magistrate out of judicial jurisdiction or within jurisdiction, or the judicial executive magistrates being able to help the police in these directions. So this is a very, very important sections for about that particular subject area. Coming to subsection 188, which is report of investigation by subordinate police officer. So 188 talks about when a subordinate police officer has made any investigation under this chapter, he shall report the result of such investigation to the officer in charge of the police station. So when you see any charge sheet flowing into the court, irrespective of who was the investigating officer, you will also see the stamp and seal of the senior police officer, the in charge of the police station, because it is his responsibility to transmit any such investigation report further to the judiciary, which means he has to do a due diligence on what is going from his police station to the judiciary. So there is a reporting procedure which is defined here, because in all the cases, 99% of the cases, because the work division is done and the composition of the police station and the type of the role of the police station, level of the police officer, the cases are distributed among them. But accountability sits on the head of the police station in charge. And how does the accountability is counted by this section is, while the report is transmitted, it is which is the duty is considered that of the police officer in charge of the police station and no one else. So, which means he will have a oversight on the investigation also, oversight on the collection of evidences also. He will have an oversight on the searches also. He will also have oversight on the interrogation also, and then he will also have an oversight on the medical test, and at end of the day, all the documentation which is going to the police station, everything is in order or as per process or not. And that is all summarized because section 198 gives an accountability, complete accountability to the charge, the officer in charge of the police station. So this gives a reporting procedure where it has to be reported via only through the officer in charge of the police station. So this gives a very important aspects what I just mentioned. Apart from that, the case management also becomes very nice because the officer in charge can make an informed decision regarding the next steps in case based on the investigation finding, and that will also help him to work on that matter, also assign any new officer if required. Oversight and accountability, as I mentioned, is already there, and it coordinates the effort. So it is also something where the bulk of it might be done by somebody else, but it is done at all the steps. He's being informed and coordination is provided. So where his knowledge, his skills, and his oversight is required, and which is also helping in grooming the other junior police officers also, which will help further empower the police department as well. So brings a efficiency in the investigation process, it brings a quality control, it brings an accountability to the police officer, and it brings an enhanced collaboration within the police station. Section 189, which talks about the release of accused when evidence are deficient. So there is deficient, if the evidences are very deficient, the release of the accused, how it happens in section 189, it is defined. So if upon an investigation under this chapter, it appears to the officer in charge of the police station that there is not sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to the magistrate, such officer shall, if such person is in custody, release him on his executing a bond or bail bond, as such officer may direct to appear, if and when so required, before a magistrate empowered to take cognizance of the offence on a police report and to try the accused or commit him for trial. So, which means an authority to release is also given to the officer in charge of the police station at the very early stage when it sees there is not much meat in the matter. So, if they believe that the evidences are lacking, there is no direct requirement, there is no direct evidence which is reasonable, unreasonable, and which is not on a reasonable ground, presenting a reasonable ground for any further investigation to be done on the person, or maybe uh, there is insufficient evidence or reasonable ground for suspicion to justify that the further legal action is required against that person. So these provisions then uphold the principles of the justice also, and that empowerment is also given to the police officer. In practical life, it happens seldom, but it is something which is also given an authorization to the police. If what are the consequences of this not happening? The consequences of not happening this is the case might get a discharge. We talked about this day before, where the magistrate when has a all the belief to believe that there is uh, no reason to run this matter further, it might be discharged at the very initial level also, where the person will be discharged of all the allegations and the um, complaints which are made against that person, and the case will not proceed any further. But this will also have a consequence where the police officer might be uh, facing a, 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 a on the instruction of the magistrate, any kind of inquiry or response submission to the senior officers in the court for the reason why it was done so. So these things quite happen, but then there is a power given to the police officer in charge, the officer in charge of the police station, to do this under section 189. Now, if the officer determines that the evidence is lacking, the person, the officer may release the accused from custody if they are currently detained. If they are brought into the police station, they are detained, they're holded in the police station for discussions, inquiry, interrogation, and then the officer believes nothing much, they can release the accused from their custody. The person can be, they can let go the person. And the release has to be in contingent upon the accused executing a bond or bail bond, guaranteeing their promise to appear before a magistrate if required. So tomorrow, if there is a requirement of a magistrate, anyways, if the case is registered and if the person is detained on retained is not retained in the custody and the person is being released by the police officer, there has to be some kind of bond, bail bond, surety, etc., which has to be given, which is guaranteeing their promise to appear before a magistrate if required. Now, this bond serves to hold the accused accountable while allowing them to regain their freedom. So, person is still available. The process still is running. The matter will still go to the magistrate, but then the person is not required to be in the police custody or further in the judicial custody. The person could be released then and there in the police station, which is a power given in section 189. An obligation to appear is something which is mentioned in subsection 1, which says the bond must ensure that the accused will appear in the court when required, and this conditional release helps maintain the integrity of the judicial process by also giving in the other hand a freedom to the person where it is not necessary to constrain his movement and detain him in any kind of custody. So the practical implication is the protection of individuals' right also happen. There is efficient use of resources also. Police also does not have to put unnecessary efforts and put resources to detain that person, hold that person, present that person for detention in the court, and blah blah blah, whatever happens after that. And it also gives an encouragement of accountability to the police officer, because by doing that particular releasing that person on such bond, the police officer also has to justify clearly why it has been done. So those things are very, very important procedure, which is given an empowerment to under section 189 BNSS to the police officer who's in charge of the police station. But these cases happen seldom. Like for a case example, if we talk about in one of my matters, that a certain police station in Pimpri-Chinchwad, they receives a complaint about a person who runs a kind of hostel and learning centers. And this person who comes to complain to the police officer is coming and talking about an incident which has happened about 15 days before, where he was threatened by the supervisor of the that particular coaching hostel and the owner of the particular hostel to be you know in dire consequence to do something which might hamper his health and life. And he did allege that there is some kind of uh, you know uh, physical fight also happened with the supervisor, where he slapped him and there was a physical abuse. But what was important is, in this case, the person in question was a person who was of a very clear background. He was a good professor in that locality, working there for last more than 10 years, delivering lectures on the various civil service examinations of state and center, and impeccable, character and history. And that person was then brought and detained by the police in case of an investigation. Now, what was the right thing to do in that case was, under this particular section, this section was available in CRPC also. So under that relevant section, he was supposed to be released on a bail bond. And as this was a complaint of a little serious nature of somebody slapping somebody and detaining somebody in the hostel room, and throwing him out of the hostel room, calling him and threatening of dire consequences, etc., etc. But then there parallelly, this was something which had no evidence presented apart from any verbal communication. There was no verbal, apart from verbal allegation, there was no evidence. There was no recording of the situation. There was no phone call recording which was presented. There was no injury. There was not any injury report also from the past which was presented. It was completely a story which was being told. It was a responsibility of the police to take an attention and make an investigation. But then there was a delay in reporting of 10-15 days also. Why on earth somebody will do that if that something happens to him before 15 days and he comes after 15 days to report? So considering that there was not much evidence, the police had gone ahead and they should have, under the BNSS 189, should have taken a bond of the person by putting all these reasons of his character, etc. They could have released him. The person who is running a center in multiple locations in the city and is a very known person will not run away for such a small matter, leaving everything behind. But instead, the police detained him and presented him in front of of the magistrate, where we had to go and immediately got a bail for his release because of his, on the same grounds what I just mentioned at the start. But then what is the consequence after that? The matter discharged in the court, session court, and then the police officers will have a disciplinary actions made against them. So disciplinary action is a different subject. Let's not go into that direction. But then these kind of procedures are given to the police officers as a situation where there is no need to overload the courts with the matters and unnecessary trouble the freedom of the people where it is not required. What does it mean? 189 in a nutshell is, it is something which is ensuring a fair use of the police resources, in turn which will help in unloading the load on the courts also. Now let's, sorry, 190. So uh, This outlines the procedure law enforcement when sufficient evidence has been gathered during an investigation. So 189 is done, 190. Let me read the wordings for you first. So this is the point where when you have a sufficient ground. Now we talked about the ground where the police officer has seen there is no sufficient ground. The person is released on those grounds with a bond, and the person could be set free. Now let's see section 190. It says the cases to be sent to the magistrate when evidence is sufficient. Now, if the evidences were sufficient, taking the same example, say in that case, if the police officer had audio video recording of the student being bashed, uh, and if there was an audio recording of the phone call where the person could have been seen threatened, there was a email or a letter which was issued to the person with the threatened. There was a history of that person doing it earlier with some other students. So in those cases, if upon an investigation under this chapter, it appears to the officer in that case, in charge of the police station, that there is a sufficient evidence or reasonable ground, as aforesaid, such officer shall forward the accused under custody to a magistrate, empowered to take cognizance of the offence upon a police report and to try the accused on commit him for trial. Now, if the offences are of bailable nature or non-bailable nature, it makes a difference. If the offences are of non-bailable nature, in that case, there is an argument required for by the counsel of the particular accused to receive a bail on the ground suggested by that particular the ground recommended by that particular advocate to the court, and then court may take a discretion to provide a bail or not. If the matter is of a non-bailable offences, still the person is presented to the magistrate. The person don't need will get a bail by default. So such officers shall forward the accused under custody to a magistrate, empowered to take cognizance of the offence upon the police report and to try the accused or commit him for a trial. Or if the offence is bailable and the accused is able to give security, shall take security from him for his appearance before such magistrate on a day fixed, and for his attendance from day to day before such magistrate until otherwise directed. Provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the magistrate and the magistrate. So in this case also, even if there is an evidence and the police has a strong belief that it is not required to keep the person in custody, we can leave the person out to be free, but still we can have some kind of security taken from the person to ensure his appearance or his or her appearance before the magistrate. And the magistrate in whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken in custody. So there is no objection can be raised by the magistrate in that case, discretion of the police officer. And when the officer in charge of police station forwards an accused person to the magistrate or takes security for his appearance before such magistrate under this section, he shall send to such magistrate any weapon or other article which is it may be necessary to produce before him. So any weapon, any article accompanying has to come to the magistrate on the first place when the matter is being presented for the first time, and shall require the complainant, if any, and so many of the persons who appear to such officer to be acquainted with the fact and circumstances of the case as he may think necessary to execute a bond to appear. So it's not only one person, maybe all the people who are connected before the magistrate as thereby directed and prosecuted or given an evidence as the case may be in the matter of the charge against the accused. If the court of the chief judicial magistrate is mentioned in the bond, such court shall be held to include any court to which such magistrate may refer the case for inquiry or trial, provided reasonable notice of such reference is given to such complainant or persons. And the officer in whose presence the bond is executed shall deliver a copy thereof to one of the persons who executed it, and shall them send to the magistrate the original with his report. So whatever is the bail bond is executed, that copy has to be given to the person executing, and the original has to go to the magistrate. So 190 is the situation when in 189 there was no evidence. There is an option for releasing on a bond to make an appearance justify guaranteed. In this case, when there is sufficient evidence, then what has to be done? So subsection 1 says options for handling the accused. It says forward him to the magistrate or forward them to the magistrate who has the authority to take the cognizance of the offense and ensuring the trial, or they can or committing for the trial. So that magistrate, that person has to be forwarded. Or in the bailable offenses, if the offense is bailable, The officer may take security from the accused to ensure their appearance before the magistrate. So if in spite of having evidence, the person is in a bailable offense, it is the police officer who can also take a security and leave the person out so that he can appear before the magistrate. And this security bond binds the accused to show up in the court on a specified date and to continue attending until the instructed otherwise. But if the accused is not currently in custody, the police officer can still take security of their appearance, and the magistrate must accept his bond regardless of the accused custody status. It does not matter to the magistrate. Requirements when forwarding the case is subsection 2. So, alongside forwarding the accused to the magistrate, the officer must also include the necessary evidence. If any evidence were, a weapon, article, etc., were recovered, that also has to be sent to the magistrate, and any bond which was signed, those bonds also in original has to be sent to the magistrate. Clarification of jurisdiction is given in subsection 3, which talks about if a CJM is mentioned in the bond. This includes any court to which the chief CJM may refer the case later for inquiry. So all the subordinate courts are also included in that, ensuring that the case can continue to proceed appropriately. So if you normally file a case in such courts, you mention that in the court of the CJM, and then the later the magistrate is assigned, and then you start going to that particular court number, to that particular magistrate. So it is automatically considered the subordinate courts also. Documentation on the bond is something where uh, the signing of the bond, whatever is done by the police officer, which is subsection 4, and who has executed that, will the original bond has to be go to the court with the report and with the action taken, and the copy has to go to the one of the persons who has signed the bond. So this is a very efficient way of case management with multiple options, where if you see in all the sections what we have seen until now, the liberty of the person is something which is of primary importance, where it cannot be curbed and should not be curbed, at least we can say, if it is not required. That is why is the direction given in both section 189 and 190 also. Even if there is no evidence, even if there is an evidence also, then also. Section 191, the title says complainant and witness. The complainant and the witness not to be required to accompany police officer and not to be subject to restraint. This is about the complainant and the witness. So no complainant or witness on his way to any court shall be required to accompany a police officer, or shall be subjected to unnecessary restraint or inconvenience, or required to give any security for his appearance other than his own bond, provided that if any complainant or witness refuses to attend or to execute a bond as executed in section 190, the officer in charge of the police station may forward him in custody to that magistrate, who may detain him in custody until he executes such bond. So 191 is talking about the rights of a complainant and witness in the legal process, which is of prime importance. So specifically protecting them from unnecessary inconvenience while attending court proceedings. So this provision underscores the importance of ensuring that individuals participating in the justice system do so without any undue process and any undue restriction. And then uh, there is no requirement to accompany a police, which is mentioned by this particular section. It says complainants and witnesses traveling to the court, when they are traveling to the court, should not be compelled to accompany police officer. They cannot be made compelled to accompany any police officer. This provision respect their personal autonomy and acknowledges that their presence in court is voluntary and not contingent upon police authority. This has both the values. If a complainant is coming to the court for their own reason, it has to be voluntary because they are the one who are making the complaint. What if they do not come to the court in spite of making a complaint, and there is no reason they could not come to the court to attend the proceedings? In that case, there might be a small presumption made later on insist of the defense that it might be a fictitious complaint also, because the person has lost an interest to continue with that particular matter, and it might dilute. There is no guarantee, but it might dilute the prosecution as well, if prosecution efforts also. So prevention of restraint is something which is also maintained in this section, where the individual shall not be subjected to unnecessary restraint. So they cannot be inconvenienced as they make their way to the court while going to the court. And this is important to maintain the dignity and right of the individuals involved in legal proceeding, ensuring that they can participate without the sense of coercion or intimidation by the police. Why a complainant and a witness should be coerced? No, there is no reason. The provisions state that the complainant or witness should not be required to provide any security for their appearance in court beyond their own bond. This removes additional burden that could deter individuals from participating and ensure that their rights are preserved. In consequence of refusal is also listed in as a provision to this section 191, where it says should a complainant or witness refuse to attend a court or comply with the direction to the executor bond, as in 190, the officer in charge of police station has the authority to take them in custody. So if there was a requirement of them putting a bond by their own, and if they refuse to do that, then the police can take them in custody as well. And upon receiving the individual, the magistrate then may detain them to in custody until they agree to execute the requirement. If it is required, then that is a mechanism which is again utilized. The detention can extend until the hearing of the case is concluded, ensuring that all relevant testimonies can be secured. So, in case if it is required, then the same provisions of 190 is applicable to them also. Section 192, which is diary of proceedings in the investigation. So, the wordings of the section says, every police officer making an investigation under this chapter, so every police officer who is in making an investigation shall day by day enter his proceeding in the investigation in a diary. So there is a case diary where they have to make a day by day records of the investigation in the diary, setting for the time at which the information reached him, the time at which he began and closed his investigation. So it has to give a start and end, the place or places visited by him, and a statement of the circumstances ascertained through this investigation. So the complete picture day by day has to be written into that diary of proceedings by the police officer making the investigation. Now, the statement of the witness recorded during the course of investigation under section 180 shall be inserted in the case diary. And the diary referred to in subsection 1 shall be a volume and duly paginated. So diary which is created is in subsection 1 is a complete volume with multiple pages, and it has to be duly paginated. Anything which goes to the court has to be paginated. Any criminal court may send for the police diaries of a case under inquiry or trial in such court, and may use such diaries not as evidence in the case, but to aid it in such inquiry or trial, because this is just an investigation which has been added by the police. It cannot be completely considered as an evidence until the elements are proved. So in that case, this is something which is aiding in the inquiry. That is what is the legal position of these diaries are. So these are the volumes of the pages in this matter, which are part of the evidence which is attached with the charge sheet when it goes to the court. And by name, it looks like is a case, the diary of the investigation which is added. But in reality, it's a multiple set of documents. It's not a proper New Year diary how you purchase. So the requirement for diary of proceeding. So it's a diary of proceeding. So that way, if you understand, you will not visualize a New Year diary. It's a diary of proceeding. It literally means that diary means recording of events with chronology. So that is diarying anything. So if you use a diary also, the name of the diary is diary because of the same meaning of the diary, because diary writing is writing day-to-day affairs in the chronological order. So this is a diary of proceeding, which is a set of paper which is coming, which is described in subsection 1, which requires every police officer who is doing an investigation, for that investigation maintain a daily diary. It has to be specific for one investigation. This diary serves as an essential record which has details about the information what they have received. So whatever at time which the officer first received information about the officer, at that time when they have received. So that information receipt is also there. FIR is also there. Investigation timeline is also there. The exact time of the officer commenced and concluded the investigation. That is also shown by that case diary. And the place visited, all the places they visited, the Panchanama, etc. Everything is which is of spatial context. Spatial context is described in the the place perspective, and then circumstantial evidences. So any statement of the fact, any circumstantial evidences, etc. during the investigational effort also has to be added to the case diary. The purpose is to not only aid in the maintaining an organized approach to investigation, but also serve as a reference point for the officer's actions and findings. It also shows not only a original record with timeline for what the investigation has happened, it also shows as a reference point for the officer's action. It also shows how his action, what were the logic and what continued in what sequence. Subsection 2 talks about inclusion of witness statements. So whatever witness statements are also are done during the investigation, those also has to be recorded section under section 180. What has been done is also documented in the same case diary. They have to attach those. You will see so and so person is neighbor, so and so name, so and so is his salary, job, address, age, and that person says this about that incident. So those are the witness statements, multiple, which are documented in the same case diary, means their pages are also added in the same volume of the pages, and it is ensures a comprehensive account of all relevant testimonies also included in the case diary, maintaining a structure and verifiable record that can be referred. So if a police officer during the case diary investigation is putting those timelines and visiting the places, describing the circumstantial evidences, they can also put the witness there, and they should put the witness to ensure a complete picture that whom he has spoken, what the person has said. Subsection 3 talks about the format of the diary, that it must be properly formatted as a bound volume and paginated. So it's a bound volume and paginated means it has to be tied by some mean, it has to be in chronological order, and it has to be paginated. Page number 1, 2, 3, 4, 5 has to be given. This structural requirement promotes an organized report. The report now becomes an organized report keeping record, and it makes easier to reference. Tomorrow, if you reference the case diary, you will come back and say page number so and so case diary, and you know that this is in a chronological order, and it is properly bound in the volumes, which definitely gives you a clear structural requirement. Now, use of diaries in the court is mentioned in subsection 4, that any criminal court has the authority to summon the investigative diaries for cases under inquiry for trial. So if a matter is already in the court and some kind of investigation is running already, or probably some reinvestigation is happening, which has been ordered, so the court can ask for that investigative diaries for the inquiry or trial. So while these diaries cannot be used as evidence, they cannot be used as evidence in the court case, they can be aid the court in understanding the context and progression of the investigation, how it progressed. This either it has to be completed or it is still in progress. This use has enhanced the judicial oversight and support a more comprehensive review of the facts surrounding. So it gives a more comprehensive view of whatever is the investigation. Now, subsection 5 talks about the access restriction of this. So it establishes specific access restriction, saying that the accused or their representatives cannot demand the diaries or view them simply because they have been referenced in the court. So they cannot be part of the parties who could demand the diaries or view them. However, if the police officer refers to the diary to refresh their memory about the case, or if the court uses the diary to contradict the officer's testimony, the provisions of 148 or 164 of the Bharatiya Sakshya Adhiniyam comes into play, allowing for the appropriate cross-examination and evidence presentation process. And in that case, the provision helps prevent a misuse of police diaries while still preserving the right of the accused in approaching appropriate situation. So, police officer can refer, and for the sake of cross-examination, etc., where the validation of uh, validation is happening through cross-examination, etc., then this could be used to ensure that the police diaries are not something which is killing the rights of the accused in the appropriate situations. That is what it is. It gives an accountability in the investigation also, that it could also be invalidated during the cross-examination, and there might be suspicions or inadequate activities, or maybe copy-paste activity which has been done, or maybe some by illegal means the diaries have been created. Those could be proved later, and for that purpose it could be used, but it cannot be used as a evidence. It is something which gives the direction of that particular crime which has happened and the investigation. It facilitates thus the judicial review also, and it gives a protection of right as well of accused. The last section in this chapter of chapter 3, which is interrogation power of the police officer, is report of police officer on completion of investigation. Now, the full report which is going on completion of the investigation, which is very, very important. So, every investigation under this chapter shall be completed without unnecessary delay. So, without any unnecessary delay, this has to happen. The investigation in relation to an offense under sexual offenses or under 4, 6, 8, and 10 of the Protection of the Children from Sexual Offense POCSO shall be completed within 2 months from the date on which the information was recorded by the police officer in charge of police station. So within 60 days, they have to complete the investigation in case of a child abuse or in case of a sexual abuse of a woman. As soon, subsection 3 says, as soon as the investigation is completed, the officer in charge of the police station shall forward, including through electronic communication, to a magistrate empowered to take cognizance of the offence of the police report, a report in the form as the state government may by rule provide, stating the name of the parties, the nature of the information, the name of the persons who appear to be acquainted with the circumstances of the cases, the uh, whether an offense appears to have been committed, and if so, by whom, whether the accused has been arrested or not, what is the position, whether the accused has been released on his bond or bail bond, then original bail bond or certified bail bond copy has to be there, whether the accused has been forwarded in the custody under section 190, or whether the report of medical examination of the woman has been procured and has been attached under any kind of sexual offenses. So all these things, all these details has to be provided alongside with the investigation related documents which we mentioned in the previous sections. The sequence of custody in case of an electronic device also has to be mentioned, and the police officer shall within a period of 90 days inform the progress of the investigation by any means, including through electronic communication, to the informant or the victim. They have to also provide within a period of 90 days the progress of the investigation. The officer shall also communicate in such manner the state government may by rule provide the action taken by him to the person, if any, by whom the information relating to the commencement of the offence was first given. So whether the such report has come in, so the sequence of custody in case of electronic devices, they have to report in 90 days. Now, subsection 4 says where a superior officer of a police has been appointed under section 177, the report shall, in any case in which the state government by general or special order so directs, be submitted through that officer, and he may, pending the order of the magistrate, direct the officer in charge of police station to make further investigation. So then the report has to be presented by this officer who has been appointed. So any senior officer in the same jurisdiction under 177, we see in that particular same jurisdiction, that officer is allowed to do that investigation as if he has the power of the same police station in charge. Subsection 5 says whether it appears from a report forwarded under the section that the accused has been released on this bond or bail bond, the magistrate shall make such order for the discharge of such bond or bail bond, or otherwise he thinks fit, whatever he thinks fit will be the fate of that bail bond. Subsection 6 says when such report is in respect of a case to which section 190 applies, the police officer shall forward to the magistrate along with the report all documents of relevant extract thereof which the prosecution proposed to rely other than those already sent to the magistrate, and the statements recorded under 180 of all the persons whom the prosecution proposed to examine as its witness. If the police officer is of opinion that any part of any such statement is not relevant to the subject matter of the proceeding, or that its disclosure to the accused is not essential in the interest of justice and is inexpedient in the public interest, he shall indicate that part of the statement and append a note requesting the magistrate to exclude that part from the copies to be granted to the accused and stating his reason for making such request. And then subsection 8 says, subject to the provision contained in subsection 7, the police officer investigating the case shall also submit such number of copies of the police report along with other documents duly indexed to the magistrate or supplied to the accused as required under Section 230, provided that the supply of report and other requirements by the electronic communication shall be considered as duly served. So it has to be properly indexed, which means it has to have an introductory index plus pagination also. Subsection 9 says nothing in this section shall be deemed to be to preclude further investigation in respect of an offence after a report under subsection 3 has been forwarded to the magistrate, and where upon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form as the state government may be rules provide, and the provision of subsection 3 to 8 shall, as far as may be, apply in relation to such report or reports as they apply in relation to report forwarded under subsection 3, provided that the further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. So they have to provide all the copies. They can restrict the copies which they believe is important to be hidden in interest of the justice or security of the witness, etc. And the copies has to be presented to the magistrate in a well paginated way with an index, and within 90 days they have to do it. If they receive further evidence in spite of submitting the report in under section 193, they can still forward those things and investigate. There is no bar on that. So it is a 193 is a section of completion of investigation. So a timely completion of investigation and how it has to be done, the report submission, that is what is described in section 193. And the time frame for specific offences are also given there. For certain offences, it is 60 days, which is the sexual offences against the women or the children. And in this case, it is only 2 months from the date of when the information was received. When it was received and recorded at that point of time, it becomes the reference point, and from that point onwards, it is urgently has to be closed within 16 days. Reporting structure is also given where the certain details have been quoted in subsection 3, which talks about what basic information has to be definitely there, although the rules could be set further by the state government to add something if the wish in specific uh, manner. For example, the name of the parties involved has to be there, the nature of the information, what has been received, the names of the witness acquainted with the circumstances, their details, offense appears to have been committed and by whom, then status of the accused, arrested or released on bond or not found, whether the report includes medical examination, then all the details which is mentioned in the previous sections of the medical report, and any other pertinent detail which is necessary for the judge's judicial review. It continued progress has to be updated. So investigation officer is to inform the informant or the victim, the person who has put that complaint in place, the progress of the investigation within 90 days. So using any means of availability, for it could be electronic communication also, and promote transparency and keeps victim informed about the status of the case, because he is the one or she is the one who is interested. So they have to inform within 90 days. And the delegation to a superior officer is also possible, which is described how it happens and what are the other elements related to that in subsection 4, which talks about if a superior police officer has been appointed, then the report may need to be submitted through that officer, and if so directed by the state government. So if the state government has that kind of rule, it can be done by the officer, and the superior officer may also instruct the officer in charge to conduct further investigation even after submission of the report in a written order, and providing an additional layer of oversight. So they can also keep an oversight and they can issue an order of that oversight to the police officer in charge. Subsection 5 talked about the accused status reporting, where if the report indicates that accused has been released on the bail, and if it is responsibility of the magistrate to make an order concerning the discharge of the bail, then that condition or other necessary legal action also is done on based on that particular investigation. While subsection 6 talks about the documentation for the trial, which says in case that fall under section 190, the police officer must submit all relevant documents and statements recorded under section 180 alongside the report to the magistrate. So everything which is found, the document, articles, everything has to be submitted. And this ensures that a magistrate has pertinent information at their disposal for proceeding. They must have every information what is required for them to act. Subsection 7 talks about the exclusion of irrelevant evidences, where if the police officer deems any part of witness statement as irrelevant to the case or believes that it is disclosure may not be in public interest or the interest of the justice, they must note that part and request its exclusion from the copies shared with the accused, and that request has to be made to the magistrate. It's a discretion of the magistrate who can take a decision if it is yes or no, could be excluded and irrelevant or not. It cannot be removed by the police officer. It can just make a note on those around that document. Subsection 9 talks about further investigation. Of course, after submission of report also, as the case is alive, there might be some further investigation also which can happen after the initial report has been submitted. If the new evidence is discovered during the additional investigation, the officer in charge must submit the further reports to the magistrate, and this rules the subsection 3 to 8, everything will apply and subsequent on the subsequent report as well. So the same rules will apply for every other rule which is applying for the initial report under section 193. And the provision also permits a further investigation to be conducted. So during a trial, but only with the court's permission if a further investigation is required after submission of all the reports, final report. So this is particularly important in case where new evidences arise that could significantly affect the outcome of the trial and must be integrated into the proceeding, or maybe an investigation by a different agency. Sometimes they come back and say investigation by CBI. So that is pertinent to the discretion and permission from the court. It can happen. So it brings in the timeliness in the justice, structured reporting, and flexibility and responsiveness along with everything which is mentioned in section 179 to 193. And that concludes chapter number 3 today, the interrogation powers of the police officer. Tomorrow we'll start in the next session with arrest with and without a warrant, exercise of power and execution rules, proclamation and attachment, etc., which is under chapter 5 of the BNSS.